This lecture walks through Ghana's Wills Act, 1971, Act 360. The focus is practical: who can make a will, how it must be executed, what can go wrong, and a few special topics like armed forces wills, dependents provision, and foreign wills. Act 360 is structured as a full roadmap from start to finish: capacity, execution formalities, witnesses, alterations, revocation and revival, custody and deposit, family protection for dependents, insurance nominations, and cross-border issues like domicile and foreign execution. The Act's purpose is to regulate how wills are made and to give effect to them. It commenced on 1 June 1971, with assent recorded on 3 July 1971, so it's been the core modern framework for written wills in Ghana for decades. Section 1 starts with capacity. Anyone aged 18 or above may make a written will under the Act, but a person who cannot understand the nature or effect of a will due to insanity or infirmity of mind lacks capacity during that period. And even if the person is otherwise capable, a will or any provision obtained by fraud, duress, or undue influence is void. Section 2 is the heart of formal validity. A will must be in writing and signed, either by the testator or by someone else acting at the testator's direction. The key ceremony is that the testator makes or acknowledges the signature in the presence of at least 2 witnesses who are present at the same time, and then the witnesses attest and sign in the testator's presence. A detail students often miss is Section 2.2. The signature doesn't operate to give effect to anything written underneath it, following it, or inserted after the signature. Visually, think of the signature as a boundary. If new gifts are added below later, they won't automatically be valid. The Act adds safeguards for blind or illiterate testators. A competent person must carefully read and explain the will before execution, and then write a declaration on the will confirming that explanation and that the testator appeared to understand. The idea is to reduce the risk of exploitation and misunderstanding. Section 3 separates 2 roles: executors and witnesses. An executor must be at least 21 and have capacity to enter into a contract. Interestingly, someone appointed as executor may still attest the will as a witness, so the Act doesn't treat that combination as automatically problematic. But the Act is strict about witnesses benefiting. A creditor can witness even if the estate is charged with debts. However, any beneficial disposition to an attesting witness, other than charges or directions to pay debts, is void unless the will is duly executed without that person's attestation and without any other similarly disqualified witness. In plain terms, if you witness, don't take gifts under that same will. Section 4 covers incorporating other documents. A will can't pull in another document unless that document already existed when the will was executed and the will identifies it sufficiently. If there's a dispute about which document was meant, oral evidence is allowed for identification. Section 5 deals with changes after the will is made. An alteration has no effect unless it's executed with the same formalities as the will, or the will is re-executed, or a codicil is later executed. And there's a practical flexibility. If the will itself shows the testator intended that a separate execution would give effect to the alteration, that separate execution can be enough. Section 6 creates special rules for members of the armed forces on active service. Regardless of age, they can make a will in 3 simplified forms: handwritten and unattested if the material provisions and signature are in their handwriting, written and attested by 1 witness, or even orally before 2 witnesses. The Act still polices witness benefits. Gifts to a witness under an armed forces will are void on similar principles. These wills remain valid even if the person later leaves the armed forces. They can be revoked either by another armed forces will or by the general revocation methods in Section 9, and they can also revoke an earlier formally executed will. Section 7 is about how courts interpret wills. A will generally takes effect as if executed immediately before death, so it speaks at death, unless the will shows a contrary intention. If someone disposes of immovable property without limiting words, the whole estate or interest they can dispose of passes, and general descriptions of land usually include all land interests, unless the will indicates otherwise. Still in Section 7, general and residuary dispositions are powerful. A general disposition of movable or immovable property can include property the testator can appoint. A residuary clause typically confers power to exercise a power of appointment, unless the will says otherwise. And crucially, residue usually sweeps in property from lapsed and void dispositions, again, unless the will shows a contrary intention. Section 7 also addresses simultaneous or uncertain order of deaths. If it's unclear who survived whom, the beneficiary is deemed to have survived the testator for purposes of taking under the testator's will. But for the reverse question, whether the testator takes under the beneficiary's will, the beneficiary is deemed to have survived the testator. It's a technical rule designed to stabilize distribution, unless the will provides differently. Section 8 explains lapse. If a gift is made to someone who predeceases the testator, or the gift is unlawful or otherwise can't take effect, it lapses and falls into the residue, unless the will shows a different intention. There's an important anti-lapse rule for descendants. If the gift is to a descendant, like a child or grandchild, and that descendant dies before the testator but leaves issue who survive the testator, the gift doesn't lapse. Instead, it takes effect for that issue, distributed per stirpes, unless the will indicates otherwise. Section 9 sets out revocation. A will can be revoked by physical destruction, like tearing, done by the testator or by someone in the testator's presence and direction with intent to revoke. It can also be revoked by a written declaration executed like a will, or by a later will that expressly revokes the earlier one. If the later will doesn't expressly revoke, it only revokes to the extent of inconsistency. The Act also prevents unfair outcomes where destruction isn't truly voluntary or informed. If the testator destroys the will because of fraud or undue influence, or under a mistake of fact or law while intending to make a different disposition that isn't validly made, that destruction is not treated as revoking the will. Section 10 covers revival. Once a will or part of it is revoked, it can't be revoked casually. Revival requires re-execution, or a written declaration of intention to revive, executed with will formalities. And if a will was partly revoked and later wholly revoked, then revived, the revival extends to the whole will. Section 11 provides a safe custody mechanism. During life, a person may deposit their own will in the High Court, sealed under their own seal and the court's seal. The point is preservation and reducing disputes about missing or tampered documents. Section 12 creates a duty after death. Anyone who has a deceased person's paper that is or appears testamentary must immediately deposit it with the High Court or another court, which then transmits it to the High Court. Failure to deposit within 14 days after learning of the death is a criminal offense, with serious penalties, up to a fine of 10,000 new cities or up to 10 years imprisonment, or both. Section 13 is a major policy feature, family protection. Within 3 years from the date probate is granted, certain dependents, father, mother, spouse, or a child under 18, can apply if the testator didn't make reasonable provision and hardship would result. The High Court may then order reasonable provision out of the estate, even if it overrides the will's terms. The Act gives the court flexible tools. Reasonable provision can include lump sums, immediate or deferred, annuities, or a series of payments. It can also include granting an estate or interest in immovable property for life, or for a shorter period, depending on what best addresses the hardship. Section 14 addresses life insurance nominations. If a policy states on its face that it's for the benefit of a family member, then unless that nomination is expressly revoked by a will made under the Act, or in another way allowed by the insurance contract, the sum assured does not form part of the estate. It's paid directly to the nominated person. Several safeguards follow. If the nominee predeceases the insured, the nomination becomes void. An insurer who pays in good faith without notice of revocation is discharged. If the nominee is a minor or otherwise unable to manage affairs, the High Court can appoint someone to administer the money, and for smaller sums, that power can be exercised by district or circuit courts within the monetary limit stated. The Act defines member of family broadly for insurance nominations, covering close relatives and several extended and step relationships. The practical takeaway is that the nomination mechanism is meant to support family members without forcing the money through the estate administration process. Section 15 is about wills made outside Ghana. A will is treated as properly executed if it conforms to the internal law of where it was executed, or where the testator was domiciled or habitually resident at execution or death, or a state of which the testator was a national at those times. This is a validating approach, aimed at upholding wills that meet at least one relevant legal system's formalities. This section also handles special cases. Wills on ships or aircraft look to the territory most closely connected to the vessel or aircraft. For immovable property, conformity with the law where the property is located is enough. A later will revoking an earlier one can be valid if it conforms to a law that would have validated the earlier will. And for powers of appointment, execution is tested against the law governing the power's essential validity. One more technical point. If the foreign law requires special formalities for certain categories of testators or requires witnesses to have particular qualifications, the Act treats those as formal requirements for these purposes. That helps the court classify and apply the right kind of rule when recognizing a foreign executed will. Section 16 is straightforward. A later change of domicile does not revoke a will, does not make it invalid, and does not change how it is construed. So the will's meaning and validity aren't destabilized just because the testator later relocates legally. Section 17 deals with territories that have more than one system of internal law on will formalities. If there's a rule across the territory indicating which system applies, the court follows it. If not, the court uses the system with which the testator was most closely connected, assessed at the relevant time, sometimes death, sometimes execution, depending on the question. Section 17 also clarifies timing. To see whether execution conformed to a law, the court looks at that law's formal requirements at the time of execution. But if the law later changes in a way that allows that will to be treated as properly executed, the court can take that into account, another validating feature. Section 18 provides definitions. Will includes codicils and other testamentary instruments. Property is broad, movable and immovable, and even rights and expectancies. Child is expanded to include adopted children, and importantly, people recognized as children in several ways, including recognition under customary law for Ghanaians. These definitions matter because they shape who benefits under anti-lapse rules and dependence provision. Section 19 is the Transition and Savings Clause. English statutes on wills, as applied in Ghana, cease to apply. Act 360 applies only to wills made after its commencement. And importantly, it does not affect the validity of oral testamentary dispositions made in accordance with customary law. So customary law continues to have space in this area. The big takeaway from the Wills Act 1971 is balance. It sets strict formalities to prevent fraud, but it also builds in protections, like safeguards for blind or illiterate testators, anti-lapse for descendants, court provision for dependents, recognition of insurance nominations, and validating rules for foreign wills. Put together, Act 360 aims to honor genuine testamentary intention while keeping succession orderly and fair.